Hello, good morning. My name is Helgi Gretason, and I'm an associate professor at the Law Faculty of University of Iceland, and I'm going to chair this panel. We will try to keep up with the time, and that is a very important objective of mine, to have a discipline. And perhaps in that context, I would like to ask you all one very simple question. What is the most important thing in life? Do you have any opinion on that? Chocolate. Chocolate, yeah, that's a good suggestion. Some other ideas? Law. Law? Some others? Please, don't be afraid. What is the most important thing in life? Time. Here comes the correct solution. Do you know why? Exactly. So, my dear friends, time is of essence today, and I welcome the first panelist. I presume you all know the three panelists. You have all the information on what this panel is about, and I have the clock, and I will give you a suggestion when there are 2 minutes left, and then the time is over. And I please welcome Mr. Professor Erik Rossaik. Is that correct? Yes. Approximately correct, yeah? To come and have the first talk.
Thank you very much. As you can see, I'm from the Scandinavian Institute of Maritime Law. Maritime law is about ships, while law of the sea is about the relationship between states at sea, and we do some law of the sea as well. My topic is the Polar Code, which is an instrument being developed by IMO to ensure safe operation of ships in polar areas. There actually are two polar codes already, and they can be a little bit difficult to find in the IMO jungle, so I put in the references here. There is, for those of you who do not know, there is a special document server at IMO where you can find all these documents. The first one is made by an assembly resolution, and the two second ones are, or the second one are found in two different circulars. And I will not go into detail about these previous codes, because they are really quite fragmentary, and they are only guidelines. But actually, there are already polar codes. Presently, there is a new, quite comprehensive code under work, and MSC, the Maritime Safety Committee of the IMO, will discuss it and perhaps finalize it in November this year. And I've here taken the outline from the maritime safety part of the code from a document to that session, which I think will be the more recent. And as you can see, there are different chapters on all the important safety aspects of operation in ice-covered areas, including operational issues and voyage planning and manning and training. I'm not an engineer, and I have looked at these things, and they look fine to me. But what I find interesting is perhaps other aspects of this code. Let's just assume that we now have a quite comprehensive instrument for safety aspects. This code does not cover essential parts of safety, such as availability of search and rescue, such as navigational aids, such as charts. They are left to the coastal states, but within its scope, it looks pretty good to me. You will also notice that there is a part 1b where there is additional guidance. You can find those things very often in this kind of instruments, and I'm not really sure about their status from a legal point of view, but at least they can be very helpful for the users. The part of the code that needed more development and perhaps has been slowest in the negotiation is the MEPC part, as the Maritime Environmental Protection Committee in the IMO. And as you can see, these chapters to some extent reflect the annexes to MARPOL, the General Pollution Convention for Ships. And this text, or these headlines and the corresponding text I've got from a working paper for the 67th section of the MEPC earlier this fall. It wasn't changed very much, but a new text has not yet been produced, at least not when I looked the day before yesterday. The code is supposed to be mandatory. And that's a new thing. While the earlier codes were only guidelines, this new code will be mandatory. That means that all flag states are supposed to implement it and enforce it for their own vessels. Technically, this is done by adding the code as a chapter in SOLAS and as provisions in the different annexes of MARPOL. I've given here the references to the draft provisions in this respect. So the mechanism is then that they will be subject to the tacit amendment procedure of these conventions. And in practice, then they will become part in a year or two of the conventions. And the flag states, being party to these conventions, will be obliged to enforce them. This also has the advantage that later amendments to the code that may prove necessary can be implemented in the same way by the tacit amendment procedure. This will work fine, or as fine as such things work, for solo ships. But of course there are quite a few ships that are not subject to these conventions, and I think there may be some small fishing vessels that maybe not should not be allowed up there at all, but they will not be subject to the Polar Code because they are too small, for example, to be part of the SOLAS regime. But of course many flag states will use the same provisions also for them. What I wanted to do is to look at the current regime, which is basically a coastal state regime, and see what kind of changes this will bring about. First of all, let's imagine that a ship going through the Northern Sea route is in a port of Norway or Russia, or at least in the internal waters. The Law of the Sea Convention doesn't have very many provisions in this respect. And certainly the port state has quite wide powers, not only to ensure the safety of the ship in port, but also for the preceding voyage. It's not very clear whether the port state actually is limited by the international conventions, and presumably the SOLAS and MARPOL as they are today are inadequate. But there is a lot of port state practice that you refuse a vessel to go on a voyage that is dangerous for that vessel, regardless of whether actually you can point to a specific provisions in SOLAS or MARPOL. For some of these passages, I think it's this sort of jurisdiction that is possible is quite important, because very many ships actually go very close to the Russian coast, or even enters into a Russian port on the way through the Northern Sea route. But Russia hasn't really been that aggressive in enforcing rules. In the territorial waters, the right of innocent passage would give very limited powers, but some powers to ensure the safety of the environment, for example. But this has to refer to general accepted rules and standards. And of course, the Polar Code will be such a rule and standard. I think also the existing guidelines in the present Polar Code would be such standards, but of course they are much more fragmentary. There is a somewhat similar regime in straits. I will not go into that, but I would mention that there are some disputes of what are one or more straits, for example, in the Northern Sea route. In the EEZ, the general jurisdiction will not give the coastal state very much power to regulate such safety measures as are now regulated in the Polar Code. But there is a special provision for ice-covered areas, which is very relevant. And there is, of course, a discussion then whether this 234 on ice-covered areas will be limited by the new Polar Code. I think the idea to put 234 into the UNCLOS in the first place was that the UNCLOS and the existing regimes were insufficient, so one would need special rules. But now we have got the special rules. There has been a debate about this in IMO, and Canada, for example, has tried to get it all clarified. But in good IMO style, states refused to clarify this. And they say they just didn't want to touch on UNCLOS, so the UNCLOS regime continued to exist. My interpretation of this is that actually the 234 jurisdiction remains, but of course that jurisdiction is subject to the proviso that the rules implemented by the coastal state must be scientifically based. And of course, when there is a general agreement on certain standards in the IMO, in the Polar Code, it's very difficult to sort of enhance those standards generally referring to general needs in ice-covered areas. There are not many special areas in the polar areas, but I would say that something similar will apply to them. The high seas, well, the coastal state had no jurisdiction, and the polar code will be very important. Same goes for the continental shelf, where the continental shelf jurisdiction is very limited to just the operation for petroleum extraction, etc. As my last point, I would mention something that is very often thought about in this connection, and that's liability and insurance. This is a crucial matter not dealt with by the polar code, but obviously there is a need for the coastal state to make sure that there is liability provisions, and Russia, for example, today only enforces the general regimes, which means, for example, that if there is an oil pollution incident outside the EEZ of Russia and the oil freezes and we need to cut out the ice to get to remove the oil, there is no insurance cover for that. This, I think, would be our next task. I think the IMO has done a lot in only a few years with the polar code. There are some legal issues here, but I think the most important thing is that we actually have got new standards developed, which I hope will be followed by the industry. The sooner, the better. Thank you.
Excellent. Thank you very much. Yes, please. So we will have questions in the end after all the three panelists have had their talk. And the next one is Dr. Walter Lathrop, of the lecturing fellow of Duke University. And his talk is on Arctic maritime boundary delimitation. Please, the floor is yours.
Well, good afternoon, and thank you, Chair, and thank you to the hosts for this opportunity to speak to you today about Arctic maritime boundary delimitations. This is how I plan to approach the next 15 minutes. I'll say a few things about the convention as a roadmap in the Arctic, give you some very basic information, which most of you already know about maritime zones of jurisdiction, and then look at where those apply in the Arctic. One of those zones is the extended continental shelf, and we'll look at what the 5 Arctic states facing on the Arctic have been doing with respect to claims to shelf. I'll run around the horn there and tell you about the individual boundary relationships among Arctic states, and then just make a few concluding remarks. We heard yesterday from the President of Iceland that there's no roadmap for the Arctic, and I would respectfully disagree that at least where ocean issues are concerned, there's a roadmap. It's the Law of the Sea Convention. The Law of the Sea Convention applies to all oceans, and the Arctic is included there. So for ocean issues, we have a roadmap. Maritime navigation, as we've just heard, the whole regime of maritime jurisdictional zones, the resource extraction of living and non-living resources in the water column, in the seabed. These are all covered already by the Law of the Sea Convention. Of course, there are other Arctic issues that aren't covered. The Law of the Sea Convention doesn't address climate change, for example, or human rights. But we do have a roadmap for the use of the oceans, including the Arctic. Just a primer on the zones of jurisdiction created by the convention or the law of the sea generally. In case it's not clear, the top panel is a plan or bird's eye view. The bottom is a side view. We have the territorial sea going out to 12 nautical miles from the coast of states in which states exercise sovereignty with a carve-out for innocent passage. The exclusive economic zone goes out to 200 nautical miles. This includes the seabed and the water column. And the coastal state within the EEZ has exclusive rights to the resources of the area. And then the, I think, most interesting zone is the continental shelf beyond 200 nautical miles. This is just an extension of the continental shelf within 200 nautical miles. It's the same continental shelf, but for the purposes of the talk, I'll call it the extended shelf. The coastal states may claim this shelf pursuant to Article 76 if they have the right shape continental shelf, physical shelf. The question of whether or not you can claim this area is based on the bathymetry, the geomorphology, geology of the shelf. I won't go into detail on how this all plays out, but suffice it to say that there are two permissive criteria which are shown in green, and two constraining criteria shown in red. And depending again on the shape of your shelf, you may be able to claim an outer limit to that shelf, which in this example would be the yellow line. This process of claiming the shelf, unlike the purely unilateral claims to territorial sea or exclusive economic zone, is really sort of a supervised unilateral claims-making process. Coastal states have to submit scientific and technical data to the Commission on the limits of the continental shelf. That commission then provides recommendations to the coastal state based on those submissions, and the coastal state, if it accepts those recommendations, can make a final and binding outer limit after having gone through that supervisory process of submission to the commission. Thank you to eBrew for this map. I don't know if it's already been shown at this seminar, but you'll see it several times during my talk today. This is obviously a map of the Arctic. It's a very full map. It's complex, but it contains quite a bit of information that's relevant to what I'd like to say today. Let me start by, I'll leave it up there for a bit so you can digest it, but the darkest shading is the exclusive economic zone. So we have the Greenland exclusive economic zone in pink, Canadian in yellow, US in blue, Russian in green, Norwegian in the orange. The black solid line is the 350 nautical mile constraint line that you just saw on a previous slide, not to be mistaken with the outer limit of the exclusive economic zone, so don't let that black line fool you. The area beyond this darker shading is high seas, so the water column here is all high seas beyond the darkest shading. What else to say about this one? The dashed dark dashed lines are notional equidistance lines. They're not negotiated boundaries. Instead, the negotiated boundaries are the ones in the solid red, and we'll hit upon those momentarily. Yeah, so the status of claims to the Arctic extended continental shelf, rather than having this up while I talk about it, let me put the map back on and tell you what these states are up to with respect to their claims to the extended shelf. Russia in 2001 made the first submission to the Commission, and it also happened to include Arctic areas. The claim is shown in this lighter green. You can see it's rather large. It includes the North Pole. That submission did not meet the standards of the Commission, and the Commission made recommendations to Russia to submit a revised submission. Now, I have never seen the recommendations. Usually they're made public. These have not been. But I assume that the Commission took issue with the Lomonosov Ridge, which is what allows Russia to make this, this size claim. Russia has made a revised submission in the Pacific, but has not made a revised submission in the Arctic, so we're awaiting that. So this large, lighter green area is in limbo at the moment. Norway in 2006 made a much more limited claim to this light area of orange here. And in 2009, the Commission returned its recommendations, largely endorsing the claim. And that is, to date, the only part of the extended continental shelf in the Arctic that's been successfully claimed by any of these states. Denmark has also made submissions, 4 of them so far, none of them in the central Arctic. So there's a submission here at the moment by Denmark, but not here yet. That's anticipated. We know that the research has been ongoing, and it's a matter of time before Denmark submits for that area. Canada, about the same status. 2013, Canada made a submission in the Atlantic and indicated that it would be making a submission in the Arctic. Again, research ongoing, and we're awaiting that submission. And then finally, the U.S., not a party to the convention and has not made a submission, but as with the other neighbors, there's been significant research undertaken, and I'm quite certain that the U.S. will claim shelf there, and it will be for the next speaker to tell you how that process might unfold for the United States. So this is the material that I just covered about the status of claims to extended shelf in the Arctic. The boundaries delimiting these various zones as between neighboring states, we show several of these solid red lines, and I'm just going to talk about the ones that actually go up into the Arctic. We've got the Greenland, Norway as a Svalbard delimitation, U.S., Russia, and then we're missing one here, which has been delimited since this map was made between Norway and Russia. Going in chronological order through the ones that we just pointed out, the 1990 U.S.-Russian boundary, this is a map from the International Maritime Boundaries Series, and unfortunately it's inaccurate where it counts, at least in my view, which is where this line heads up into the Arctic. It's shown as ending at 200 nautical miles, but in fact the text of this treaty is quite clear that this extends along a line of longitude to the limit of the zones as permitted by international law. This has yet to enter into force, but it's been around for some time. Greenland and Norway in 2006, a relatively straightforward equidistant boundary. This map doesn't show the 200-mile limits, but they are at the southern and northern ends of this line. So once the Commission process unfolds fully, and we see where, in particular, Denmark's zones of jurisdiction end with respect to the extended shelf, the two parties will have to do some more work at both ends of this boundary. And then the most recent Arctic boundary is between Norway and Russia, signed in 2010 and entered into force in 2011. There are, in my view, a lot of interesting parts to this this boundary, one of which I'll just point out, and it was also the case in the U.S.-Russian boundary, that the states essentially traded area, so areas within 200 nautical miles of Norway, but on the Russian side of the boundary, were in essence handed over to Russia for the purposes of exercising the jurisdiction that Norway could have exercised, transfer of rights, which is quite interesting to me. Those are the 3 that have been delimited. The boundary here that isn't shown on this map, but we just saw the boundary here, and then the boundary here coming out, accurately depicted with an arrow on this map between U.S. and Russia. those are much less interesting than the ones that haven't been delimited. Greenland and Canada have gone out just to the point where you see here in the red, but haven't delimited out into the central Arctic. They'll need to do so. My understanding is that they have done so by and large. I haven't seen the treaty. I don't know what the status is of that treaty, but I assume that we'll see it at some point. I also understand that it wasn't terribly contentious and that the parties, I'm going to assume, used an equidistance line. So I would expect to see something not unlike this line here when that treaty is made public. It will end presumably at a tri-point with Russia, depending on what happens in the commission process for all three of those states, Denmark, Canada, Russia. In the Beaufort Sea, between the U.S. and Canada, we don't have a delimitation, and we have a much more serious situation in terms of the departure of the two views, which is indicated by this green triangle here. The area is full of goodies. I don't know what the status of that negotiation is. I have not heard that it's active at the moment. I'm not with the U.S. State Department or the Canadian Ministry of Foreign Affairs and Trade, or whatever it's called these days. But I do know that the U.S. is negotiating other boundaries around the world with the Bahamas and in the Pacific. So I understand this to be on hold. And then the last set of boundaries are these new boundaries. They would be exclusively extended continental shelf, no EEZ, between the opposite states, whose only interaction from a boundary perspective would be created by the extended shelf rights that they may or may not get in the end. Of course, Denmark, Russia, Canada, Russia, and Denmark, Canada would all intersect somewhere in the middle of the Arctic Ocean. You'll note the location of the North Pole. Russia is claiming it in its extended shelf claim. It falls from an equidistance perspective in Danish continental shelf. And I think if I'm right about how this delimitation goes, that Canada has essentially ceded it in its negotiations with Denmark, at least. The law of the sea is the roadmap in the Arctic for ocean issues. Overlapping claims to maritime zone create tensions here, clearly, but delimitation is one of the many ways in which coastal states in the Arctic have been cooperating, and we assume that they will continue to cooperate on these issues in the future. Thank you.
Thank you very much for your interesting talk. And now the third and the final panelist, Bjarni Magnússon, will have his talk, and it's named "The Pathway for the United States to Establish the Continental Shelf Beyond 200 Nautical Miles in the Arctic Ocean Without Becoming a Party to UNCLOS." It's a very short name. Please, the floor is yours.
Thank you, Helgi. It's a pleasure to be here and speaking after Coulter. Last conference that we were together, we ended in karaoke in Tokyo. So I don't know what happens tonight. Maybe something similar. Well, anyhow, I'm going to speak about the United States, which seems to be, of course, rational. If you're Icelandic, Iceland has been speaking on behalf of United States interest. At least did so often in the Cold War, so I'm going to just continue in that spirit. So, the United States is the only Arctic state that is not a party to UNCLOS, as Coulter mentioned. And although most provisions of UNCLOS are regarded as customary international law, the outsider status of the US causes problems in some areas of the law. One of these areas concerns the continental shelf beyond 200 nautical miles. And this issue is of importance in the Arctic because the extended continental shelf of the US according to the US, could prolong more than 600 nautical miles from the north coast of Alaska. And even if all accession attempts have failed in the Senate, the accession of UNCLOS is still on the task list of the US government. But given the deadlock in the Senate, there is little chance that the US will accede to UNCLOS in the near future. So consequently, the question must be asked whether it is possible for the US to establish a continental shelf beyond 200 nautical miles without becoming a state party to UNCLOS. And if it is possible, how should the US proceed? And as Coulter mentioned, according to UNCLOS, the continental shelf extends at least to a distance of 200 nautical miles from a coastal state. And if a coastal state fulfills the rather complex criterion, it is entitled to the continental shelf beyond the 200 nautical mile limit. And many are of the opinion that non-parties to the convention do not enjoy such entitlement beyond 200 nautical miles. You can, for instance, see a statement from the president of the Law of the Sea conference, the third Law of the Sea conference, where he states that the continental shelf beyond 200 nautical miles is only for state parties. And one of the reasons why some have been reluctant to be open for the idea that states that are not parties to UNCLOS are entitled to the extended continental shelf is that the convention is supposed to be a package deal with no option of cherry picking. And one of the trade-offs in the negotiations that led to the creation of UNCLOS was that the definition and outer limits of the continental shelf were negotiated together with a requirement to share the revenues of the continental shelf beyond 200 nautical miles, at least to some extent. And no mention is made of non-parties in the revenue sharing regime. Well, we must however have in mind that UNCLOS is not the only source for the international law of the sea. Customary international law is the source of law which the United States has focused on in this context. In 1987, there was this interagency group that established the policy of the US on the delimitation of the outer limit of the United States continental shelf. And this is still the main US policy in the field. The interagency group decision provided that the delimitation provisions of Article 76 of UNCLOS, a provision concerning the outer limits of the continental shelf, reflect customary international law, and that the United States will use these rules when delimiting its continental shelf and in evaluating the continental shelf claims of other countries. And more precisely, the group mentioned paragraph 1 to 7 of Article 76 in this context. These paragraphs define the continental shelf and contain rules regarding the maximum extension of the continental shelf beyond 200 nautical miles. And it's interesting that the 87 policy does not mention paragraph 8, which is the main provision on the role of the Commission on the limits of the continental shelf. And the Commission's primary task is to examine submissions containing information regarding the outer limits of the continental shelf beyond 200 nautical miles from coastal states and make recommendations concerning the outer limits. The limits of the shelf established by a coastal state on the basis of these recommendations shall be final and binding. And it must be emphasized that it is up to the coastal state to establish the outer limits through its domestic legal system. And one reason why paragraph 8 is not mentioned in the US policy could be that submissions to the CLCS are linked to the date of entry into force of UNCLOS for the relevant submitting state. And this link is a strong indicator that only state parties can submit information to a CLCS. And so far, an international court or tribunal has only stated that paragraph 1 of Article 76, which includes the definition of a continental shelf concept, is customary international law. Scholars have, however, gone further. Ted McDorman, a Canadian scholar, has pointed out that there appears to exist sufficient state practice based on the 1958 Geneva Convention on the Continental Shelf and upon Article 76 of the Laws Convention itself to support the view that as a matter of customary international law, a state may legally exercise jurisdiction over the continental margin beyond 200 nautical miles, irrespective of that state's status as a Laws Convention party. And McDormand notes that the clearest example of this state practice is the Maritime Boundary Limitation Treaty between the US and Mexico regarding the Gulf of Mexico from 2000. The treaty fills a gap in the Gulf which is beyond 200 nautical miles from the coast of the two parties. No state has opposed to it. And Thomas Mensa, serving as ad hoc judge in the Nicaragua-Colombia case that was decided before the International Court of Justice in 2012, stated in his declaration, it can plausibly be argued that the entitlement of a coastal state to a continental shelf beyond 200 nautical miles arises under customary international law, whether or not the state is a party to UNCLOS. The procedure by which a non-UNCLOS state can assert its right may be different, but the ability to assert it should be recognized where the necessary conditions exist. So, if we accept that non-state parties to UNCLOS are entitled to the continental shelf under customary international law, we have to find a pathway to establish the outer limits. So, arguably, to assert its title, the US could make a public declaration about its entitlement and the exact location of its outer limits. The declaration could include a commitment to honor the revenue sharing regime of UNCLOS. The outer limits should be based on paragraph 1 to 7 of Article 76 of UNCLOS and be justified with reference to customary international law. The next step, or a simultaneous step, would be to establish the extended continental shelf under US domestic laws. Thereafter, an attempt could be made to deposit charts and relevant information describing the outer limits with the UN Secretary General, and the next step could be to make all the scientific evidence for the entitlement public. Actually, the process has been quite, we can say, open concerning the United States. And in this context, it must be kept in mind that the institutions established with UNCLOS have no standing before international courts or tribunals to challenge the outer limits of coastal states or any other formal channel to do so. Other countries could, however, challenge the US. Consequently, the response of other states would be of vital importance in this context. And following a reasonable period where no protests or objections are made by other states, the outer limit claimed by the US would arguably be considered final and binding and not open to contest. Now, we get to the next challenge. If the United States attempts to establish its outer continental shelf in the Beaufort Sea, the US will not only have to convince other states that it is entitled to the continental shelf beyond 200 nautical miles, it will also have to conclude a maritime boundary with Canada, as Coulter discussed. And one aspect of the situation in the Beaufort Sea is similar to the maritime dispute between Nicaragua and Colombia. That is, Colombia is not a party to UNCLOS, while Nicaragua is, just as the US is not a party while Canada is. Therefore, attention must be given to a few statements made by the majority in ICJ's judgment. And it must be noted that the statements of the ICJ, which I'm going to mention, is what is called obiter dicta. That is, they were unnecessary for deciding that case. And if you are extremely interested, I'm talking about paragraph 126 of that judgment. First, the judgment can be read as providing that states have to go through the CLCS procedure before delimiting the continental shelf beyond 200 nautical miles between neighboring states. And as I mentioned previously, we have to bear in mind that the CLCS path is only open for parties to UNCLOS. And this position, that is that you have to go through the CLCS procedure before delimiting maritime boundaries beyond 200 nautical miles, is controversial and not in line with state practice. And more important for this presentation, the court noted, as you can see here, given the object and purpose of UNCLOS, the fact that Colombia is not a party thereto does not relieve Nicaragua of its obligations under Article 76 of that convention. 3 judges responded critically to the statements of the majority. That is, for instance, the US Judge Donahue, which noted that, as you can see here, that the court today appears to suggest that it will not entertain a proposed delimitation of continental shelf beyond 200 nautical miles off the coast of a state party to UNCLOS unless the procedures contemplated in UNCLOS Article 7 have been completed, even if the second state involved in a delimitation is not an UNCLOS state party. The stated rationale is that Nicaragua's obligations to other UNCLOS states parties. Nicaragua has obligations to its treaty partners, of course, but the court offers scant explanation for its conclusion that those obligations preclude delimitation in this case. So, if UNCLOS is to be interpreted in the manner as the ICJ did in future delimitation, it can have consequences. Some might argue that the US and Canada could not delimit the outer continental shelf in the Beaufort Sea until Canada has made its partial submission concerning the Arctic Ocean to the CLCS, or even until the CLCS gives its recommendation concerning the submission. In contrast, state parties and non-state parties have delimited the outer continental shelf in practice without any response from third states or other actors present in international law. So to sum up what I've been saying, there is a pathway for the US to establish the extended continental shelf. If the US follows this pathway, its success depends on the response of other states. And if it is accepted that the US is entitled to the continental shelf beyond 200 nautical miles, the statement in the Nicaragua-Colombia case can be an obstacle. The obstacle can, however, be overcome, as you can read about in my forthcoming book, The Continental Shelf Beyond 200 Miles, Delineation, Delimitation, Dispute Settlement, which Brill will publish in the beginning of next year. So buy it. Thank you.